Hi guys, welcome to Legal Brilliance. Today we will be discussing on features of Industrial Dispute Act 1947. Let's begin with the introduction. The Industrial Dispute Act 1947, it extends to the whole of India. This act came into operation on 1st April 1947. This is a labor legislation which is enacted with the very purpose to regulate and maintain industrial peace and economic justice in industries. Main features of Industrial Dispute Act 1947. First feature, the Industrial Dispute Act lays down a comprehensive machinery for prevention and settlement of industrial dispute. This act is both a substantive and procedural law which is aimed at promoting industrial peace and preventing industrial disputes. Substantive laws, for example, IPC, it defines the punishment and defines the crime. Wherein procedural laws are those laws such as CPC, CRPC, which speaks about procedure as to what has to be done when certain crime is committed. Industrial Dispute Act is both a substantive and procedural law because it speaks about procedures for retrenchment, procedure for strikes, lockout, and it also speaks about penalty when any illegal act is committed. That is why Industrial Dispute Act is both substantive and procedural law. Third feature. The main object of the Act is to harmonize the relationship between employer and employees so as to maintain industrial peace and hence to ensure social justice. Fourth feature. Any industrial dispute may be referred to industrial tribunal by any agreement of parties to the dispute, or it can be referred by the state government if it deems necessary to do so. Here, industrial tribunal is a body which takes up in any sort of industrial dispute and it decides over the case. Fifth feature, an award means a decision. Basically, award is a decision of an industrial tribunal, national tribunal, or board of conciliation, which shall be binding on both the parties to the dispute for a period not exceeding 1 year, and this shall be enforced by the government. Sixth feature, the right to strike by the workers and lockout by the employers are prohibited in following circumstances. First condition, when conciliation and adjudication proceedings are pending. Second condition, when settlement in conciliation proceeding is pending. Third condition, whenever award of industrial tribunal is pending. So in three following conditions, strikes and lockouts are prohibited. Seventh feature. In the public interest or in case of emergency, the appropriate government, as per section 2A, it is either the central government or the state government has a full authority or full power to declare the transport, coal, cotton, iron and steel industry to public utility for maximum period of 6 months. Eighth feature, in case of layoff or retrenchment, that is, in case of temporary termination of employee or permanent termination of employee, the employer is required to pay compensation. Ninth feature, this act provides for provision for payment of compensation to workmen in case of transfer or closure of an undertaking or establishments. Tenth feature, the authorities such as Work Committee, Board of Conciliation, National Tribunal or Industrial Tribunal are provided for settlement of industrial dispute by this act. 11th feature, Industrial Dispute Act prohibits unfair labor practices and penalty can be imposed. 12th feature. This act provides for provision for penalty for commission of illegal act. This is dealt under section 26 to 31 of the act. Usually penalty are in the form of fine or imprisonment. With this, we come to the end of our discussion on second part of Industrial Dispute Act. Thank you.